Well, good morning, everyone. We'll go ahead and call this meeting of the Hearing Instrument Fitters and Dispensers Advisory Board to order. The time is exactly 10 a.m. on Wednesday, March 11th, 2026. Everyone would just please keep your microphones muted unless you're speaking. When you do speak, state your name for the record, and please keep your camera on so quorum can be confirmed. So for now, we'll go ahead and ask Angelica Lopez Sparks to conduct the roll call and confirm quorum.
Yes, sir. Christopher Beisel,
Chris Beisel, present.
Erica Vella,
Present.
Vanessa Myers,
Present.
Matthew Toohey,
Here.
Lance Brooks,
Here.
Deidre Stewart, and Presiding Officer Dusty Potter.
Here.
You have a quorum, sir. You are muted, sir.
Sorry, I was following my own instructions. All right. Thank you, Angelica. We also have new board members joining us today, and we'd like them to briefly introduce themselves. First up, we've got Erica Vella.
Hi, as he said, I'm Erica Vella. I've been in the industry for about 30 years. I was on the manufacturing side for 20, and then I had 3 private practice clinics for about 11 years and recently sold them, and now I'm back on the industry side. Happy to be a part of this.
All right. Thank you, Erica. Up next, we've got Vanessa Myers.
Hi, I'm Vanessa Myers. I've been practicing for over 20 years. Currently private practice owner, and we have 2 locations, and I'm also happy to help on the board in any way that we can.
All right. Thank you, Vanessa. And up next is Matthew Toohey.
Hey guys, I'm again Matt Toohey. I'm in the Orange, Texas area. Been in the hearing industry for about 17 years. Kind of grew up in the business, worked with a family business since 1962. My grandfather started it, but looking forward to help out with the board however I can, and I appreciate the opportunity.
All right. Thank you, Matt. Appreciate all of you being here, and welcome to the board. Up next, we've got open government training. I'll go ahead and call on Assistant General Counsel Chris Funderburg to provide the briefing on the Open Meetings Act, Administrative Procedure Act, and Public Information Act. Chris, the floor is yours.
Thank you, Mr. Presiding Officer, and other board members. I'm hoping that what you're seeing now is the open government trading. Is everyone able to see that?
Yes.
Yeah, thank you. So, as Mr. Potter said, I'm Assistant General Counsel Chris Funderburg. I'll be going through the open government training the department is required to give the board members every year. The training covers 3 statutes, and each require transparency in government and public participation. These statutory mandates impact the function of each advisory board associated with TDLR, hence this presentation. The first statute that we'll discuss is the Open Meeting Act. The second is the Administrative Procedure Act, also called the APA, and the Public Information Act, also referred to as the Open Records Act. So we'll start with the Open Meetings Act in Chapter 551 of the Government Code. Excuse me. It requires that meetings of government bodies be open to the public, and there has to be a notice ahead of time to let the public know what the meeting will be about and where and when it will convene. The courts have held that these provisions are in the Open Meetings Act are mandatory, and they're to be liberally construed in favor of this policy of open government. There are 3 key terms associated with the Open Meetings Act: quorum, deliberations, or alternatively discussions, and meetings. A quorum is the majority of the members of the advisory board as fixed by statute or rule. A quorum of the governmental bodies, including an advisory board or committee, must meet in order to take official action. We'll move on to the next one. Deliberation, or alternatively discussion, is the second key concept. Deliberation means a verbal or written exchange between a quorum of a governmental body, or between a quorum of a governmental body and another person concerning an issue within the jurisdiction of the governmental body. And third, a meeting occurs any time a quorum of a governmental body engages in deliberation regarding public business or public policy, over which the governmental body has supervision or control at any time the body takes formal action. If a if a governing body takes formal action which requires a quorum, or if the quorum engages in deliberation, either occurrence is classified as a meeting. Once that threshold is reached, the requirement notice of the OM may attach. The Act requires advance written notice of the date, time, place, and subject of each meeting held. TDLR provides this notice in the form of an agenda. Notices must be filed with the Secretary of State at least 7 days before a meeting and must be posted online by both TDLR and the Secretary of State. A board or committee may not engage in discussions about a subject not included in the agenda. This is why the board cannot engage in back and forth deliberations with public commentators, as the subject of the subject matter of the discussion is a variable and could not be specified in the agenda. So a reasonable follow-up question: what about social function, conventions, and workshops? If board members engage in a verbal or written exchange about an issue outside of the jurisdiction of the governmental body, it is not a deliberation. Thus, the public doesn't have to be notified about the deliberation, and that deliberation doesn't have to be an agenda item. If 5 members of the board meet at the grocery store and discuss the price of eggs, this isn't a meeting that requires notifying the public. Or if during the meeting the board deliberates on where everyone wants to go to lunch, the lunch discussion doesn't need to be an agenda item. Keeping in mind that a meeting occurs whenever a quorum of a governmental body engages in discussion about an issue within the governmental body's jurisdiction, can members ever meet in an informal setting without violating the Open Meetings Act? And the answer is yes. Members are free to engage in conversation that is incidental to the event. However, the discussions will be subject to the Open Meetings Act if a quorum of members is involved, and the members either engage in a discussion or make decisions about a board or committee business or take formal action. So some key points to remember. Always be aware of any situation occurring outside of a properly noticed meeting in which a quorum of members is present or engaged in discussion. Do not engage in substantive conversations relating to board or committee business or policy when a quorum is involved and you're outside of an officially noticed and scheduled meeting. And third, beware the walking quorum, which we'll go into a little bit more. So a walking quorum occurs when, I'll back up a little. The formation of a quorum isn't limited to a specific time or location. Rather, quorums form through communications between board members. These communications can easily occur outside of a formal board meeting, and the communications can stack on top of each other, often without the board members realizing it. This reality creates the risk of the walking quorum. A walking quorum occurs when fewer than a quorum of members engage in discussion about official business and then communicate these discussions to other members. While fewer than a quorum of board members participate in the initial communication, subsequent communications with other members will result in a quorum discussing official business outside of a public meeting. And we'll give some examples. On a 5-member advisory board, 2 members exchange phone calls and emails expressing thought on an upcoming rule change and exchange research they have each individually performed on the issue. One of the board members subsequently forwards the exchange to another member. The members have now engaged in a walking quorum by engaging in a small group discussion outside of a properly noticed board meeting. Walking quorums can occur during conference calls, video conferences, hallway discussion, email, text message, and other new technologies. The walking quorum concept, combined with newer technologies such as X, formerly Twitter, Facebook, and instant messaging, raises new issues about meetings and compliance with the Open Meetings Act. So the best policy practices to avoid a walking quorum: board members should not meet in small groups, discuss board or committee business, and then communicate those discussions to other members. They should not send emails or text messages to the quorum of members regarding official business, even if each email is addressed and sent to the member individually. They should not create posts on social media about board business where a likelihood exists that a quorum of members could participate in discussions, or ask a quorum of members, even on an individual basis, for feedback or comments on board or committee business outside of the public meeting. This is also called polling, which is essentially conducting an informal vote on an issue. The guidelines for open sessions, the best practices to avoid violating the act on basis of insufficient notice: members should limit discussions to specific agenda items contained in the posting or agenda filed with the Secretary of State. Avoid allowing discussions regarding specific agenda items to wander off course into new issues that have not been noticed to the public. Not respond to or discuss issues that are raised during public comment but which are not on the agenda, and specifically identify items for future agenda and communicate those items to TDLR staff. Now, now the there are real penalties associated for violating the Open Meetings Act. Civil remedies include allowing any interested person, including the media, to petition the courts to stop action taken in violation of the Open Meetings Act. The Open Meetings Act also specifically states that an action taken in violation of the act is voidable. There are also criminal penalties associated with violations of the OMA. Members who knowingly participate in a walking quorum or who knowingly participate in a meeting that is closed to the public are subject to misdemeanor criminal penalties. The penalties are a fine of $100 to $500, confinement in county jail for 1 to 6 months, or both fine and jail time. So again, the best practices for the Open Meeting Act: avoid communications that involve a quorum of board or committee members about official business outside of a properly noticed public meeting. And during open meetings, confine discussion to an item specifically posted on the agenda. And this is, the Open Meetings Act is a dense and very a dense and complex area of the law. And if you're interested in researching this more, there are some links here that we provided. Now, with the OMA discussion out of the way, I'd like to turn to the Administrative Procedure Act. The purpose of the Texas Administrative Procedure Act is to establish minimum standard of uniform practice and procedures for state agencies, and to provide for public participation and transparency during the rulemaking process. We'll actually be engaging in rulemaking later on during this advisory board meeting. The APA's definition of a rule is a statement of general applicability made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. A rule excludes a statement regarding only the internal management or organization of a state agency and not affecting private rights or procedures. A rule includes a new rule, an amendment to an existing rule, and the repeal of an existing rule. There are multiple sources for rulemaking: legislative changes, which again is kind of the impetus for the rulemaking that we'll be discussing later, advisory board input, TDLR staff suggestions, 4-year rule review, which is required by Texas legislation, and rule petitions. A rule petition allows any interested person to submit a petition to a state agency requesting the adoption of the rule. An interested person is defined as anyone who is a Texas resident, a business entity located in Texas, a government subdivision in Texas, or a public or private organization that is not a state agency but is located in Texas. Here's a brief flowchart overview of the rulemaking process. As you can see, it starts with the rule idea and drafting and moves effectively into the effective date of the rules. We're at the first advisory board meeting step. Again, we have a small rulemaking that we'll be presenting to the board. If that meets with the board's approval, the existing text will go ahead and file the proposed rules with the Texas Register, and that will start the 30-day comment period, and then we'll bring back those rules with those comments for the board's review and comment as well. The rule review process: all programs are on a 4-year rule review schedule. Every 4 years, the administrative rules that govern a profession are subject to review by the regulatory agency. With the hearing fitter and dispensers rules, Texas administrative rules are not currently under review, but this is the process that is implemented when it is time for the 4-year rule review. Again, the dense and complicated area of the law. Here are some resources if you'd like to look into, if you'd like to research this further. And finally, we get to the Public Information Act. The Public Information Act, or Open Records Act, is intended to allow public access to information about the affairs of government and the official acts of public officials and employees. The Act makes all documents, records, and other information relating to official business open to the public, with some exceptions. Public information includes any electronic communication created, transmitted, received, or maintained on any device if it is connected with official agency business. And the Act is supposed to be construed liberally in favor of granting requests for information. The department receives requests for public information. The public may request copies of public information or request to inspect the information in the offices of the governmental body, and requests must be submitted in writing. At TDLR, the requests are submitted through our online portal, the TDLR Records Center, which can be accessed on the TDLR website. There's a part of the open records process requires timely response by TDLR. We must respond to the request as soon as possible, but not later than 10 business days after receiving the request. We cannot ask why someone wants the records. We can only ask for clarifications through the GC Open Records team. The general rule, there is a general rule and common exceptions to disclosure. The general rule is a presumption of openness, but certain information is required to be redacted from open records. Examples include date of birth, most email addresses, driver's licenses, license plates, VIN records, credit card numbers, and private medical information protected by HIPAA or the Texas Medical Records Privacy Act. And an OAG Office of Attorney General ruling must be sought to redact or withhold any other information. If you, as an advisory board member, if you receive a written request for record or correspondence that looks like a public information request, please forward the request ASAP to the advisory board team, who will forward it to the Office of General Counsel, Open Records team. If the GC Open Records team requests information from you as an advisory board member, please respond as soon as possible. The 10-day business line, 10 business day deadline applies to all requests, no matter who receives them. Again, but if you'd like to look into this area of the law more, we've included some links. That concludes this. That concludes my presentation. I just wanted to, at this time, to say that while I've been privileged to be the GC assigned to the to this profession for the past couple of years, Elizabeth is going to be taking over as a GC. I'm probably going to present the rulemaking for at this advisory board meeting and the next advisory board meeting. But after that, I will the transition will be complete, and Elizabeth will take over. And I just wanted to allow her to introduce herself to the board.
Good morning, board members. As Chris said, my name is Elizabeth Salinas Strittmatter. I've been with TDLR for almost 9 years now. We recently had a shuffle amongst general counsels working on different programs. And I wanted an opportunity to take on a new program in the health area of TDLR. So I was fortunate to get appointed to this one, and I look forward to working with all of you. And feel free to reach out to me anytime. As Chris mentioned, the training, we always have that in the back of our minds. So if you ever have any questions, please feel free to call me or to email me at my TDLR address, and I will get back to you as soon as possible. But thank you for having me, and I look forward to working with all of you.
All right. Well, thanks very much to both of you. So at this point, board members should have received the minutes in the meeting materials from the prior meeting. Does anyone have any comments or corrections on the minutes that were provided to them? Okay. Well, if there are none, I'll entertain a motion to approve the minutes as presented.
This is Lance Brooks. I would make a motion to accept the minutes as presented.
Chris Beisel, second.
All right. Angelica, if you would, please conduct a roll call vote.
Yes, sir. Chris Beisel,
4.
Erica Vella,
4.
Vanessa Myers,
4.
Matthew Toohey,
4.
Lance Brooks,
4.
and Presiding Officer Dusty Potter.
4.
Motion passes.
All right. Thank you. All right. So we do have a public comment that was accepted via email according to the instructions in the meeting agenda. Advisory board received the one emailed comment, and it was distributed to board members prior to the meeting. So I guess we'll now move on to staff reports. So we've got Charles McCain for the licensing division.
Good morning, advisory board members. My name is Chara McCain, and I am the team lead. I am the team lead of Health Professions Team Licensing Division, and I am here to provide to you the staff report for hearing instrument fitters and dispensers, and you have the copy in front of you. So for hearing instrument fitters and dispensers, as of the first quarter of 2026, we issued 18 new licenses, 96 were renewed, with a total population of 770. For apprentice permit, 10 new licenses were issued, 14 were renewed, with a total population of 64. And lastly, for temporary training permit, 34 new licenses were issued, 11 were renewed with a total population of 190. That concludes my report, and I will be happy to answer any questions you may have. Thank you.
Okay, up next, we've got Michael Ford Strawn with the Education Examination Division.
Good morning, Chairman and members. Especially welcome to our new advisory board members. Thank you all for serving and being here today. My name is Michael Ford Strawn. I'm the new director for our Education Examination Division. Started about December, beginning of December. And so still fairly new into this role, although I've been around the agency for quite some time, so you may recognize my face. But I'm here to give you our education examination statistics today and answer any questions you have. So on the screen right now, you'll see our practical examination statistics, where we're pretty much in line with what you saw for FY25, about a similar pass rate overall, sitting about 85, 86%. And the volume also checks out for what we've seen in prior years for this first quarter as well. You'll see the note on there that examinations are only offered or administered in September Q1, January for Q2, and May Q3. We did have last year in FY25, we had special sessions in both June and October. We're also doing 2 special sessions this fiscal year as well, and I'll comment on those a little bit more here in a minute. So you can go ahead and scroll down as you were. Here's the breakout of the portion statistics between the audiometric and the ear impressions. This is just sort of the breakout of what you've seen above, so you can see where exactly candidates are passing and failing within this practical exam, what they're being more successful at. It seems to favor the fact that ear impressions are a little bit higher of a pass rate than the audiometric side of the practical examination. If you'll scroll down for me again, please. These are our continuing education statistics and jurisprudence examination stats. Again, these are tracking exactly within what we'd expect to see from fiscal year to fiscal year. So nothing really of note standing out there or any comments that I have on that. And if you scroll down, we'll have our projects and updates that we have. So the updates we have, we're reminding everybody that continuing education, hearing instrument fitters and dispensers required to complete 20 hours of continuing education within a 2-year license period. One thing that people may not know is that we do audit these CEs to make sure that individuals have completed their continuing education when they're renewing their license. This is a process that is done here in my division. When you are selected for audit, we're always telling everybody, make sure you're holding on to your documentation, make sure you have that information. When you come up for renewal, you'll be getting something at the same time, letting you know you were selected for audit, and you must submit those documents to us. There's a portal in which they can upload that information. Licensees, if they miss this, they don't understand it, we will follow up with them several times. Our goal is to make sure that we get these CE audits completed, work with everybody to get their documentation in, not just send people to enforcement or anything else, but we always want to make sure everybody is aware this is a process. You are going to hear from us as far as auditing your continuing education. And the instructions, all the requirements are posted on our website for anybody that wants to see that. And then last, we had the exam updates. So this is what I was talking about earlier in the presentation. Ourselves, our examination vendor, and THAA have been holding additional practical examinations at annual conferences. We have the next one coming up in June 11th, 2026. And we're updating this candidate information bulletin with those additional examination dates. I did want to point out at this point in time, we have the upcoming dates scheduled. We have practical exams scheduled for March 21st, May 23rd, the June 11th one you see on your screen, and then September 19th. So we're trying what we can do to make more examinations available or opportunities available for people to take their practical exam for this purpose. We are always looking for additional persons that maybe want to serve as a rater for our practical examinations as well. So if you know anybody that's interested in helping us, that is the easiest way for us to offer additional opportunities out there. is by having additional volunteers that can help us hold these practical examinations. With that being said, that concludes my my presentation, and I'm happy to answer any questions you have today. Thank you.
All right, thank you. All right, well, if there is no questions, then we'll go ahead and go with Myra Rodriguez with the Customer Service Division.
Good morning, board members and TDLR staff. My name is Myra Rodriguez, and I'm one of the managers in the customer service department that oversees this program for customer service. As you can see here, in comparison with fiscal year 2026, we only have the first 2 months of the second quarter. If you take a look at the January data, it's going to be 236 total contacts versus fiscal year 25, which we were at 201. It looks like for this fiscal year, we have just a little bit more phone calls than last fiscal year at this time. And they've increased by about 30 contacts or so, give or take a little bit. But that concludes my report. We haven't seen too much of a difference, and I'm available if you have any questions. I'm available for any questions that you may have.
Okay, if there is no questions there, Alana Manzanares with the Enforcement Division.
Hi, good morning, board members. My name is Alana Manzanares. I'm a prosecutor for the Enforcement Division. I'll be presenting the report to you today, covering key statistics and case highlights. At the very top of the report, you have the division's performance measures. You'll notice that fewer cases have opened this year compared to the same time last year. The next section is the criminal history review for applicants who may have disqualifying criminal history. As you can see, none of the hearing instrument fitters and dispenser applicants were denied licenses based on their criminal history. The next section details where the Enforcement Division's complaints come from, whether they're from consumers or from within the agency. The pie graphs at the top of the next page visualize this information for you. In the orders issued section, you can see that we had no orders this year. On the next page, you can see that there's a small increase in complaints related to unethical conduct, but records violations have declined. Then going down to the violations resulting in disciplinary action, you can see that there are none for fiscal year 2026. At the bottom of the report, we have 2 case highlights for you to review. And finally, we have 1 hearing instrument fitters and dispensers subject matter expert. We are actively seeking hearing instrument fitters and dispensers that are in good standing to serve as subject matter experts to assist our division with complaint case reviews. And that concludes my report. I'm available to answer any questions.
Thank you. If there's no questions, we'll go ahead and move on to Erica Rodriguez with the Compliance Division.
Hi, good morning, presiding officer and board members. My name is Erica Rodriguez, and I will be providing our Compliance Division staff report for today. I'll go ahead and begin with our personnel update. Ari Acevedo joined our Health and Wellness team in August. We actually stole Ari from our Education and Examination Division, so thank you, Ford. She's been a great addition to our team, and she is going to serve, and she will be serving as my backup for the program. Next, a quick update on our current projects. We're currently implementing several bills from the 89th legislative session. While a few impacted TDLR's health and wellness programs, there was one in particular, Senate Bill 904, that directly affected our hearing instrument fitter and dispensers program. Senate Bill 904 made 3 key changes. First, it simplified the rulemaking process for hearing instrument sales by removing the previous requirement for co-approval with the speech language pathologist and audiologist advisory board. So this just allows us to update rules more efficiently and streamline. Second, it removed the continuing education exemption for new licensees in their first 24 months. This is just to ensure that our licensees are up to date on new techniques and research. And then the third key change is it removed the requirement that only physicians specializing in ear diseases may authorize the purchase of a hearing instruments for minors. It now allows any licensed physician to sign the authorization statement, to ensuring that compliance with the federal law and increasing access to hearing instruments for minors. On June 24th, 2025, we led a standard of care joint work group meeting, and this was to discuss drafting a proposed rule regarding licensees to notify clients if a hearing instrument is locked. Mr. Brooks will be reading our report here shortly in a moment. We also assisted our Education and Examination Division with updating our website. This was just to reflect the new CE rules that went into effect May of last year. In addition, as Ford mentioned earlier, we are in need of proctors to proctor the exam. So we added an additional page to our website explaining how licensees can earn CE by proctoring our practical test. So if anyone is interested that's watching or listening, you can find more information on our website in regards to that information. We are partnering with our vendor, CGI, and all our departments to develop a course. It's called CORE. It's going to be a unified licensing system that's going to consolidate all of our existing systems. This will be implemented in phases, and when your program or our program transitions, all licensees will receive detailed information about the new process. Finally, we continue to assist other divisions and respond to daily industry questions and emails. For outreach, sorry, I apologize. For outreach, I presented program updates with Katie Bryce at the Texas Hearing Aid Association conference last June. And then we also continue to work on the TDLR Health Monitor newsletter. Our most recent edition was published on February 23rd. You can find the past editions on our agency webpage. And then we are excited to attend the Texas Hearing Aid Association conference in June. We will have a booth there, so if you're there attending, stop by and say hi, or if you have any questions, feel free to stop by and we'll be able to assist you there. If anyone has any outreach opportunities that you would like us to attend or to give a presentation, please feel free to contact me, Erica Rodriguez, and I'd be happy to assist with that. This does conclude my report for today. If anyone has any questions, I'm available to answer them.
Okay, well, if there's no questions, we'll move on to Steve Bruno for the agency update.
Thanks, Mr. Chairman. Thank you all for being here, and welcome to all the new members. Thank you for your service. This is Steve Bruno, Deputy Executive Director for Licensing and Regulatory Services here at TDLR, and I'll begin my update by explaining why I've added that term licensing and regulatory services. That's because during this past session, we were also assigned former agencies, the Texas Lottery Commission and the Bingo board. So we've got a lottery licensing and regulation side and a lottery and bingo side of our agency now. And the two agencies are working together to continue out all assigned duties, and things are moving along quite nicely. The other important update I want to talk about was mentioned by Erica, my colleague, and that's our CORE program. I'm the executive sponsor of that. And as you all know and have experienced, our agency has continued to grow. And part of that growth is when we're assigned other agencies, we often take on their licensing systems. And that led us to a great deal of older systems. And we are working on a modern project that will both make the experience better for you all, our external users, and for our staff and internal users. We will be keeping you updated on this important project. And as we get closer to your program coming online, we may be reaching out to some of you as experts to help us review certain features and test certain items. So we are very much looking forward to that. It's about a 3-year project that we're working on. Other quick updates, you heard from the newest Director of Education and Examination, Michael Fort-Strawn, who's been in place now for a couple of months. Just so you know, the other directors of the divisions I oversee, in the Enforcement Division, we've got Ron Foster. In Compliance, it's Charlotte Melder. Customer Service is Craig Howard. In the Licensing Division, we've got Heather Muir. And again, forward for education and examination. Those are the divisions that I'm privileged to work with, and they impact many of your, those are the ones that you interact with mostly. If you have any questions or comments, I'd like to serve as a resource. You've got our advisory board, but I am also here to help you out in any way that you need. And otherwise, I would be happy to take any questions or comments. I would like to add quickly, please do pay attention. We're about to go into our strategic planning process. For those of you who have been part of our agency for a while, you know that we'll be sending out some questions and surveys and conducting a few sessions around the state to gather input. Strategic planning is a time when all state agencies in the interim year, the years between the legislative sessions, seek input on possible improvements or changes you might like to see to the agency and to your program. So please look out for that. It's a time when we really enjoy hearing the input from you, our licensees. And that will conclude my remarks, and I'm happy to answer any questions or comments.
Okay, well, if there's no questions from everyone, just thank you to all of you staff members. You guys, great reporting here, very good information. We're happy to have it.
Yeah, it is. Thank you. Thank you all. Again, I want to acknowledge again because it's worth it. I know how much all of you make for your service here, which is nothing. So we do thank you. You are a critical link to us and to our commission when decisions are made or any issues come up with this profession. So thank you all very much for your service.
Thank you.
And I did
All right,
believe I may, excuse me, if you will, our field inspections division does, I did not mention them. They're led by Chris Russey. Thank you.
Okay, great. So up next is discussion and possible recommendation regarding proposed amendments to chapter is it 112 rules related to the hearing instrument fitters and dispensers program, or 402, right?
Chris Funderburg, General Counsel. 402 is the statutory
Okay.
authorization, and then the Chapter 112 is the administrative rules that
Okay,
govern
good.
hearing instrument fitters and dispensers.
All right, so these amendments implement statutory changes from Senate Bills 904 and 2075 from the 89th legislature and upcoming existing rules. Changes include allowing advisory board members to serve full 6-year terms, regardless of appointment timing, and extending the presiding officer term from 1 year to 2 years. So I'll call on Assistant General Counsel Chris Funderburg to present the proposed rule amendments.
Thank you, Presiding Officer Potter, and also thank you to the rest of this board. I just want to make sure, is everyone see the rule draft in front of you right now?
Yes.
Thank you. So, as I was saying, Chris Funderburg, General Counsel. Erica Rodriguez did a great job of giving you a preview of the rule changes. The proposed rules package I'm presenting today is a relatively simple modification of the Texas Administrative Code, Chapter 112, the administrative rules governing hearing instrument fitters and dispensers. The impetus for these rule changes were several bills passed by the state legislature during its 2025 session, specifically Senate Bill number 904 and Senate Bill 2075. Since you have the proposed amendments in front of you, now I'd like to summarize the changes. First, in 112.12a, the proposed rules remove language that would require the 6-year terms of the 3 members of the advisory board to expire on February 1st of each odd number year, allowing the advisory board members to serve their full 6-year terms, regardless of when appointed. Next, in 13A, the proposed rules change the advisory board's presiding officer's term from 1 year to 2 years. The proposed rule changes to 32C2 now require applicants seeking their initial renewal of their hearing instrument fitters and dispensers license to complete 20 hours of continuing education. Next, the proposed rules amend 112.70I and remove the exception that allowed the department to renew a license of a licensee who does not comply with the applicable continuing education requirements if the applicant is within the first 24 months of licensure. So we used to be able to grant an exception if they were within the first 24 months and hadn't completed their continuing education. Now the department is no longer authorized to do so. Next, the proposed rules change 112.140A to remove the requirement that the Commission adopt rules governing the sale of hearing instruments with the assistance of both the Hearing Instrument Fitters and Dispensers Advisory Board and the Speech Language Pathologist and Audiologist Advisory Board. Instead of requiring this joinder, now what one board can act without having to have both boards get together and hammer out the details. Finally, the proposed rules add a new section 112.140F. This new rule allows hearing instruments to be sold to a minor with a written statement signed by a licensed physician, rather than requiring that the statement be signed by a licensed physician specializing in diseases of the ear. These are all the amendments proposed by this rule package. As I mentioned, it's relatively straightforward and uncontroversial, I hope. If you have any questions, I'd be happy to answer them. And if you'd like to suggest any changes be made to these proposed rules, now is a great time to do so. But if you approve of the proposed rule text as it is, then I'd like to ask the board to take a vote to make a motion and a second to publish these rules for publication in the Texas Register for public comment, which would be the next step towards their enactment.
All right, thank you, Chris. So at this time, we'll need a motion and a second to publish the proposed rules in the Register for public comment. Do we have a motion?
I make a motion that we adopt the proposed rules. Chris Beisel.
All right, do we have a second?
Just real quick, I just want to confirm. So this motion is to publish the rules in the Texas Register for public comments. I just want to make sure that's the motion that we're looking for.
I was seeing a lot of veterans for.
Eric Azella, I second.
Chris Vanderbeek, yes, and Helica, that's what we're looking for. Thank you.
Ms. Vella, are you the one who seconded that? I apologize.
Yes, I second that.
Okay, so Angelica, please conduct the roll call vote.
Chris Beisel,
4.
Erica Villa,
4.
Vanessa Myers,
4.
Matthew Toohey,
4.
Lance Brooks,
4.
and presiding officer Dusty Potter.
4.
Motion passes.
Thank you.
All right, thank you. So up next, we've got the Joint Rules Work Group report with Lance Brooks. So Lance, you want to take it from here?
Sure. Thank you. Mr. Chairman, very much. Appreciate that. It was a joint work group report with board members from both the Hearing Instrument Fitters and Dispensers Advisory Board, as well as the Speech Language Pathologist and Audiologist Board. There was, on June 24th of 2025, the joint group met to discuss an administrative rule change requiring the disclosure of locked hearing instruments to clients, a topic previously raised during the April 29, 2025 Speech Language Pathologist and Audiologist Advisory Board meeting. And the issue has received some federal attention. So the work group proposed amending the 112.140 requirements regarding the sale of hearing instruments to require a supplemental written disclosure in the client's contract informing them that they are purchasing a locked hearing instrument. The additional language will require the owner to ensure each client purchasing a new hearing instrument or has a change of model receives a written contract that discloses to the client the following. Number 1, that the hearing instrument is classified as a locked device. Number 2, the definition of a locked device. And 3, disclose language that the hearing instrument contains proprietary software and that this software necessitates that repairs, adjustments, or replacements will be handled exclusively by the original manufacturer or network affiliated clinics or providers. So this rule change aims to protect consumers by ensuring they are aware of limitations on where they can seek services for their devices. Chris Funderburg, TLR's Assistant General Counsel assigned to this program, will begin drafting proposed rules.
All right, thank you, Lance. So up next, we've got work group appointments. So we've got appointment or reappointment of work groups. Angelica, you want to take it from here?
Yes, sir. All right. So for this board, we have 5 work groups. I'm going to share my screen here in a second. Some of these only have 1 member assigned, so we'll need at least 3 more. We can have 4 members because 5 will make it a quorum. So let me go ahead and share my screen. But what we're looking for is some volunteers for each one. Each one will handle a different, I guess, division area, like so enforcement, licensing, education, and examination. All right. So are y'all able to see that? Okay. So for the first one is the enforcement work group. So you would be helping review and make recommendations regarding criminal conviction guidelines, penalty matrix, and enforcement related matters and rules. For this one, we just have Mr. Brooks. So we'll need 3 more members for that one. For licensing, you'll be helping with recommendations for licensing requirements and other administrative matters. For this one, we have just Mr. Brooks. And we have a lot of vacancies because we had people resign, and of course now we need to appoint some new members to it. So that's why we have a bunch of openings. Next is the education and examination work group. This one will help with CU requirements, education examinations, things like that. This one just has Mr. Potter. And then we have standard of care. This will help with standard of care and scope of practice matters and rules. And this one we just have Mr. Potter. And the last one is the joint rules work groups. This one will work with members from the Speech Language Pathology Advisory Board. And on this one, we just have Mr. Brooks. So is there anyone who would like to be appointed to the enforcement work group?
I would volunteer for the enforcement work group. Chris Beisel.
Okay. Anyone else? And you're allowed to be on more than one. Obviously, Mr. Brooks and Mr. Potter on a few.
I'll volunteer.
Who was that? I'm sorry.
Erica Bella, I'll volunteer.
And then it went to.
I apologize. I'm having a hard time seeing everyone, so I can't say who's talking. Okay, we need one more.
Dustin Potter, I can join that one as well.
Okay. For licensing, we just have Mr. Brooks. Anyone else?
Matt Tui will volunteer.
Vanessa Myers, I volunteer.
Erica Bella, I'll volunteer.
Okay. Oops. All right, for education and examination.
Yes.
Erica Bella, I'll volunteer for that. So
Okay.
Vanessa Myers.
Okay. I'm loving all the volunteers. No one has to be voluntold. All right, one more.
Matt Tui.
I know some of y'all are volunteering for multiple. Some will obviously meet more than others, so just keep that in mind if you're worried about for volunteering for too many. Some may not need to meet for a little while, some might meet more often. It just kind of depends on what needs to be discussed. So standard of care.
Chris Beisel, I'll volunteer for standard of care.
Okay. Anyone else?
Vanessa Myers.
All right. One more.
And
sign me up, Erica Bella.
Love it. All right, last one is the joint rules work group. This is, again, the one that will work with the Speech Language Pathology and Audiologist Advisory Board.
calling you.
Yeah, Erica Bella.
Okay.
Dustin Potter.
All right, one more spot.
Vanessa Myers.
I will email all of you this list. And again, when we have a matter that needs to be discussed, staff will be reaching out to you to schedule that work group meeting. All righty, that was easy.
Yeah. Thank you to everyone for volunteering.
Yes, thank you.
Up next, we've got future agenda items. Are there any recommendations for agenda items for the next board meeting?
Chris Funderburg, General Counsel. I just wanted to advise the board that in addition to having the a draft of the locked hearing instrument administrative rules ready to go, we also there's been some interest in the behavioral analysis profession about the use of AI within their profession, and I might suggest that as part of one of the rulemaking work groups that this this topic be explored by the various board members. We have a draft of the AI rules in the behavioral analysis program, so that might be of use in this profession as well. I'm probably going to be suggesting this to the Speech Language Pathology Advisory Board as well. So.
Elizabeth Salinas, Strittmatter, Assistant General Counsel. I would actually second that. I think most of our professions are going, especially the health professions, are going to have to start looking really closely at AI and how it impacts both the statute and the rules and your everyday practices. So it would be great for that work group to, really start working and digging in. Happy to help lead that. We have actually in the general counsel's office, one of our assistant general counsels who really likes this area, and she's been giving us a lot of information about how AI is being used. And I think this is the right time for all of the boards, but particularly this one, to begin those discussions as we begin to see AI becoming more real and harder to distinguish between real people and created content.
I think that would be a good discussion for the next meeting. Procedurally, what do we need to do to add that to the next meeting agenda?
Just tell me. I'll make sure it gets on there.
Okay. Yeah, let's talk about that next time.
I will also say we will also have the public comments from the rules that will be published in the Technical Register, so that'll be on the agenda as well.
Okay. Any other recommendations for agenda items for the next meeting? Okay. Appreciate you recording the suggestions, Angelica. If anyone thinks of additional items later, just please email over and we can get those added.
Yep. Thank you all. Those are great suggestions. Thank you, Stephen and Elizabeth.
All right. So Angelica's going to pour in regard to the next meeting date. Angelica's going to.
I'm sorry.
report.
Thank you,
Oh, go ahead.
Chris. I'm sorry.
No, it's fine. It's fine.
I thanked Chris and Elizabeth. Thank you,
I'm
Chris
flattered.
and Elizabeth. Excuse me and pardon me. But I know that's a topic that we've been hearing a lot, as everyone said. So thank you all for that. Appreciate it very much. And now, thank you all for the meeting. I'll go back on mute.
All right. So Angelica's going to pull the board later to coordinate the date and time of the next meeting in regard to that. And if there is no further business, then the meeting is adjourned. It's currently 10:53 a.m. on March 11th, 2026. Thank you to everyone for being here.